solicitor or expert advocate attend the continuing healthcare assessment?
Our view, and we feel that that's supported fully by the national framework itself, is that yes, absolutely, an individual can have an advocate appointed, be that an expert specialist advocate or indeed a solicitor, to attend every aspect of the assessment process to represent their interests. Now, the reason I feel so confident in being able to say this is that the national framework itself clearly sets out the principles that should be followed by the assessment teams via the clinical commissioning groups. One of the key principles of the decision support tool assessment clearly states that the individual should be given the opportunity to be supported by or represented by a carer, family member, or friend or advocate or other representative if they so wish. We don't see that could be much clearer, and we feel that the same principles apply where the patient themselves has lost mental capacity and they are being looked after through the process by a family member or representative. Why should the stated position be any different simply because the individual's lost mental capacity? That would make no sense. Further, the national framework itself states that where any person chooses to have a family member or other person representing their interests, such as an advocate, that person should be operating fully independently of the local authority and the clinical commissioning group. So in those circumstances, it makes it very clear that if an advocate is in place, it should be entirely separate to the clinical assessment team, be that either the nurse or the social worker. So again, it lends itself to support the idea that an advocate does have a place in the assessment process. Now, further going on from that, the national framework also states that where the individual chooses to have a legally qualified person to act as their advocate, that person would be acting with the same status as any other advocate appointed by the individual concerned. So what they're getting at there is that this isn't envisaged as a legal process, it's an internal NHS assessment process. So a solicitor can be instructed to act, but they're not there in a legal capacity. This isn't a court case, they're not there to be making legal arguments, but rather they are there to be an advocate with expertise in continuing healthcare funding. I do feel that there is a place for solicitors because by virtue of their qualification and training, they will have significant experience in advocacy and the ability to be able to represent somebody's interests based on an argument of evidence, which is what this centres upon. Building on from there, another reason that we feel it's abundantly clear that there is every entitlement to have an advocate at an assessment process is that the national framework makes it clear again that it should be a person-centred process. It's stated on repeated occasions throughout the national framework that as a minimum it's necessary to ensure that the individual or their representative concerned is fully and directly involved in the assessment and the decision-making process. Clearly, any attempt to exclude an advocate or representative from that assessment process and decision-making rationale flies in the face of that, and it does not sit with the intended open, transparent process that should be taking place when an individual is assessed for continuing healthcare funding. Now, that is the point in terms of the NHS process itself. The point in law, we feel, further supports the entitlement that an individual may be there. We have had feedback from clients who have been told that unless they hold a health and welfare lasting power of attorney or a deputyship for health and welfare for the patient, they are not entitled to be involved in any way, shape or form in the assessment process. This is fundamentally wrong for a number of separate reasons. The main point being, as we've just gone through in detail, that the national framework at no stage makes any requirement known that an individual has to have a lasting power of attorney for health and welfare or a deputyship for the same level of authority. It's not a legal process, and for those reasons the NHS should not seek to rely upon an area of law to exclude individuals who in essence may be there to assist and the individual in securing the funding. Any attempt to do so clearly is a bar to the envisaged open and transparent process we've already talked about. Further, we've had individuals being informed that even where they do hold a lasting power of attorney for property and financial affairs, or an enduring power of attorney, or indeed a deputyship for property and financial affairs. They are told that that is insufficient and that a health and welfare power of attorney or deputyship is required, and again they're not able to instruct a third party such as a solicitor or an advocate, or they're not able to engage in the assessment process itself but can simply observe. Once again, fundamentally wrong. First and foremost, continuing healthcare funding is an investigation to determine whether somebody should be paying for their care on the basis that their needs are primarily health needs. If they are primarily health needs, the NHS meets the cost of care in full. We are discussing funding care, the cost of care. If that does not fall under the umbrella of a property and financial affairs matter, I'm not sure what does. And again, this is something that is made clear by the court in this area, who have stated categorically through the Court of Protection that they will not grant health and welfare powers of attorney, health and welfare deputyships where the individual has lost the ability to enter into a health and welfare power of attorney because they have lost mental capacity, simply because the level of power that that affords is far beyond what is necessary for an individual to have in place to be able to represent a person's interests. If they have a deputyship for property and financial affairs, or if they have a lasting power of attorney for property and financial affairs, that, together with the Mental Capacity Act, is more than sufficient to be able to represent an individual's interests as required. Best interest decisions can be made, and therefore an NHS assessment team saying that you require something that cannot be secured, as the courts have set out, is utterly unreasonable and can only be an attempt to restrict access to expert representation through this process. The national framework states that any advocate representing should be separate to and independent of the social services and the National Health Service within the national framework. For that reason, it makes no logical sense, other than all we can assume is it's an attempt to bar expert representation in terms of the assessment team having a worthy opponent, if you like. This should not be an adversarial process. It should be the case that it's a matter of working with the family and the patient to ensure that if they have a need, they're entitled to the funding and that is provided. And yet, time and again, where we experience what can only be construed as attempts to restrict representation and to be very difficult excluding parties, one can only assume that it's a deliberate attempt on an adversarial basis to try and weigh the process in their favour. If they had nothing to hide and it was an open and transparent process, why on earth would it not be possible for the family, who have no experience of continuing healthcare funding up until this point, to be represented by an expert? It makes no sense, and therefore we take great issue with any attempt to restrict access to this sort of expertise for the reasons we've set out. Hopefully this should be a clear indicator to anyone watching this video that if you are the responsible party for an individual who may be close to losing mental capacity, we would stress and urge that at the earliest opportunity a lasting power of attorney for both property and financial affairs and health and welfare is secured. Now, obviously that would need to be with the express consent of the individual involved, but so long as they are able to provide that consent and are willing to appoint somebody to act as an attorney in those circumstances, it can save a whole host of problems further down the line. Where we have examples like we've just discussed, where an individual can be barred from having appropriate representation, or the NHS can seek to bar them having appropriate representation because that legal authority in the form of a health and welfare power of attorney is not available, we would suggest that there is a very real need to ensure that there can be no problems and no objections, would be to secure that document at a point in time that you have it. Please rest assured, however, that if you don't have a health and welfare power of attorney and the individual has lost mental capacity and is no longer able to secure it, you should not be concerned that you will not be able to be represented and you cannot partake in the assessment process. As I've set out in detail, any such attempts by the NHS to act in that manner would be wrong, and we would be able to assist and argue the point on your behalf to ensure that you are correctly represented. What I hope is clear is that this is not a straightforward process, and you can encounter a number of hurdles thrown up which are wholly wrong and wholly incorrect, but nevertheless you need to ensure you have an expert in your corner, be that Compass or an equivalent expert, but you need to have an expert in your corner to ensure that you are correctly represented and that you stand the best possible chance of ensuring that where a patient is entitled to the funding, they will secure it as swiftly as possible. Now, if you have any queries regarding continuing healthcare funding, or indeed how it applies to your relative's particular circumstances, you shouldn't hesitate to contact us directly. We are available by phone on 0121 227 8940. One of our expert advisors will be more than happy to have a totally independent, confidential and importantly free discussion with you on a no obligation basis to go through how continuing healthcare funding works and how it may apply to your particular relative's circumstances. Separately, we do have a website, of course, at www.continuing-healthcare.co.uk. There should be a raft of information of use explaining continuing healthcare funding, and hopefully you'll find the video blogs like the one you're watching now to be of use explaining the different issues you may encounter. Thank you very much.